Hi, this is Huang Lei, CFP, EA, and real estate professional in California. In this video, the focus is on what the surviving spouse actually has to do when a husband or wife dies with no will and no trust. In California, that situation is called dying intestate, which means state law decides who inherits and how property is transferred. The first point to understand is that California distinguishes between community property and separate property. A surviving spouse generally keeps their own half of the community property and usually inherits the deceased spouse's half of the community property as well. But separate property may be shared differently depending on whether the deceased left children, parents, or siblings. So what should the surviving spouse do first? Start by ordering multiple certified death certificates. Those will be needed for banks, title companies, life insurance carriers, retirement custodians, and often the court. Next, gather every asset and liability statement that can be found. That means the home, rental properties, bank accounts, brokerage accounts, retirement plans, life insurance, vehicles, and business interests. Then sort them into categories: community property, separate property, joint assets, beneficiary-designated assets, and assets titled only in the deceased spouse's name. After that, determine which assets transfer automatically and which do not. Assets with beneficiary designations, such as many retirement accounts and life insurance policies, often pass outside probate. Jointly held assets or assets with survivorship features may also transfer by operation of law, while assets titled only in the deceased spouse's name may require a probate or a spousal property procedure. In many cases, the surviving spouse must file something with the court. If there is property in the deceased spouse's name alone and the estate does not qualify for a small estate shortcut, probate may be required. The surviving spouse is generally at the front of the line to ask the court to be appointed to handle the estate, collect assets, pay valid debts, and complete distribution under California intestacy law. When the main issue is the family home, title matters a lot. If the property was held as community property with right of survivorship or in joint tenancy, the surviving spouse may be able to record an affidavit and a certified death certificate to clean up title. If the property was community property without survivorship language or was in the deceased spouse's name alone, the spouse may need a spousal property petition or probate court orders before the title can be fully updated. Another important step is to review taxes and basis. A spouse's death may create a step-up in basis for appreciated property, and that can have major capital gain consequences if a home, rental, or stock portfolio is sold later. This is one reason the surviving spouse should coordinate with both an estate attorney and a tax advisor early in the process. A practical warning belongs here. Do not leave assets stuck in the deceased spouse's name. That often creates bigger problems later when the surviving spouse tries to refinance, sell, retitle, or distribute property to children. If a spouse dies with no will or trust, the surviving spouse should not assume ownership issues solve themselves. The right next step is to inventory assets, confirm title, determine whether probate or a spousal petition is needed, and get professional guidance before making transfers. If you want more videos on how taxes, investments, real estate, and estate planning all fit together, hit like, subscribe, and drop a comment.